Good day to you. In this Paddocks Club tutorial, I'm going to talk to you very quickly about the fundamentals of mixed schemes. Now, what do I mean by the term mixed schemes? Well, let me give you some examples. The classic inner city mix will have a building that has retail on the ground floor, offices above it, a residential component perhaps above that. It might have a parking garage that starts on the ground floor and goes up for a portion of the whole building. It might well include a hotel, separate gyms and other things, each of which have access to give access to the public in and out. A less extreme example is the suburban style, the thing you will often find in suburban areas. A retail component on the ground floor and then residential above that. You also get purely residential schemes or purely office schemes that have completely different components. They're different because either the parts are built at different times or they're built with different materials. Very often it's both different times and different materials. So you can have any number of different types of mixed schemes. Now, if you get one of these babies at the beginning, the developer looks at it and thinks, look, this is a mixed scheme, I need to have a sensible approach because I know that just managing it as one sectional title scheme isn't going to work. You then go through a process of defining what areas of common property will be exclusively used by particular components as well as by particular owners, so that you're creating exclusive use areas in those two dimensions. You are also ensuring that the services are either separately delivered in terms of the systems that exist to deliver them, or that they're separately metered at the critical points defined by who's paying what cost. And you create separate cost centers. In your rules, you make a provision that this thing won't be run as one sectional title scheme. Yes, it will be within the confines of the Act, but that it will be there will be sub-accounts in terms of which the residential and the commercial and whatever else exists will be run, and levies will be collected differently. And you provide for separate trustee groups most normally, at least to consider those things that only affect one particular group, one particular component in the scheme. And you might well consider using developers' conditions as part of the mixture of legal medicine that you cook up to make sure that this thing works well in future. But of course, very often we come to this, as we have quite often in the discussion forum recently, where in fact what is needed is not a design, not a creative exercise before the scheme is built, but a retrofitting of a legal separation of components to an existing scheme. In this case, Section 20A rules, 27A rules give you the possibility of giving certain people use rights and giving with those use rights also the obligation to cover the costs of that area. Section 32.4 allows you to make rules that adjust the financial consequences of the participation quotas, and in that way to say, well, these chaps have a particular feature which means that the insurance costs more and therefore they will make additional contributions outside of their PQ contributions to cover that excess, and so to relieve any other component from subsidizing them on that particular issue. And you'll find that there are a lot of issues where there is cross-subsidization, and what one is trying to do is to unpick the natural consequences of sectional title and of the undivided ownership in common property by way of rules made under 27 and 32.4, so as to create separate cost centers in effect and separate administrative arrangements where those are appropriate. You definitely, to do that, will probably need, you'll need at least special resolutions. You may need unanimous resolutions depending on how the thing is put together, and you might need to consider taking the whole thing to the High Court if, for example, there are certain owners who simply won't agree to it, and you need a unanimous resolution. Or in future, I'm hoping that the CSOS intervention, where they can simply make rules that are appropriate after hearing all parties. Thank you for joining me in this lightning overview of mixed schemes, and if you have any questions, you're welcome to ask them in the discussion forum.